Mr. Lewison.
Question 8.
Divorcees with children under their legal custody, care and control may form a family nucleus by listing their children as essential occupiers in their flat application. Those awarded shared care and control of their children share the right to list the children in their flat application. This is rare, as care and control is usually awarded to one parent. As any individual can only be listed in one HDB flat application, we require parents with shared care and control to seek their ex-spouse's agreement before listing the child in a flat application. This ensures fairness to both parties, as HDB is not in a position to determine which parent should exercise the right to list the child. Nonetheless, those who cannot reach an agreement with their ex-spouse may approach HDB to discuss their options.
Mr. Lewison.
So I thank SPS for the reply, but I have two clarifications. I understand that the shared care and control is actually a court ruling, and it's so that the children following a divorce will be able to live with both parties. But then our housing policies now penalize them for having this shared care and control instead of sole care and control. So I'm wondering whether MND can work with the courts so that we can align our policies so that the judgment that is obtained can actually be enforced and is feasible. Second clarification is that HDB had initially said that we had removed the time bar because we realized that it caused friction between both parties because they can't decide on who will get the subsidized housing. We also said that we removed the time bar in the best interest of the children involved in the divorce. But now that we have this back to this ex-spousal consent on who can list the children as occupiers, wouldn't we be back to square one again? And would SPS agree that this will again lead to friction between both parties because they now have to again decide on who will get the subsidized housing?
I thank the member for his question. Now, time bar aside, divorced couples with shared care and control with their child, as I mentioned, are still required to obtain their ex-spouse's written agreement before they apply for a flat. And this is because both parents have equal rights to buy a flat with their child. And HDB is not in a position to determine which parent should exercise the right. This is also to be consistent and fair to all HDB flat owners and households where each person can only be listed in one HDB flat. But for those who face challenges in reaching an agreement, HDB will exercise flexibility. If they face financial difficulties or lack family support, we will ensure that parents with shared care and control have options to provide housing for themselves and their children. So I think we recognize that each of the family circumstances are different, and it's best to take an approach where flexibility can be exercised to meet their specific circumstances and needs. Thank you.
Ms. Raju.
Thank you, Speaker. Thank you, SPS, for your clarification. I'd just like to take this opportunity to echo Mr. Louis Ng's concerns in this matter, because I'm a practicing divorce lawyer, and this is a matter I see fairly commonly. Even if the order is not a shared order, even if it's just care and control to one parent, there's always this disagreement and issues with regards to the housing arrangements, because only one party can list and use the children's name. I would just want to highlight and stress the difficulties that parties have. This becomes an issue of contention because they have difficulties arranging for their housing later, especially in shared care and control arrangements. Parties have difficulties resolving it in the divorce. So it doesn't help in the resolution of the divorce if we don't figure out how we can lay out plans that can help parties moving forward. So along in this line, I would propose, there's already this housing guidance arrangement that is given to parties at divorce. They have the standard query to fill in, and there's housing guidance. From my experience and from anecdotal evidence given by clients who have gone through the process, depending on the officer, the advice given may not necessarily be as thorough and as helpful. So I believe that I think in circumstances where there is a divorce, it would be helpful if parties are given a very clear outcome, a very clear option that's available to them, especially at that stage before they actually go through the whole divorce process, so that they can see, how much loan they can actually take out, how much money they have, what are their options. They have all this in broad terms, but it doesn't really help because they give, just rough figures, or sometimes to an extent that they won't even give the indication of the housing loan eligibility because you don't have the divorce order yet. I think there's a hesitance of actually fixing a certain amount before they actually know the full picture. But I think, to be fair to the parties, you really need to guide them along. So one, I would suggest that you review the process in respect of housing guidance to help the divorce parties. And two, I would just echo Mr. Ng's point that we may need to review this position about making it an exception because the policy itself does not gel with the principle of a shared care and control arrangement, because the parties are actually ordered to be able to allow the children to live with them. So the idea is that, okay, half the time they're living with the father, half the time they're living with the mother. If they don't have proper housing in place, there will be some difficulties. Thank you, Speaker.
I thank the member for her very comprehensive sharing, and I note that you have worked with parties before, so you thoroughly understand the situation. We understand the concern that mutual agreement might be difficult, and as I mentioned, we will exercise flexibility for those who face financial hardship or lack family support, and we will take a needs-based approach and take each family's circumstance into account. We will ensure that parents with shared care and control have options to provide housing for themselves and their children. On the housing counselling for divorcing parties, I'll take your feedback back to make sure that the officers who interact with the divorcing parties are understanding, take all their sharing into consideration, and hopefully that can help to make the process less taxing for all parties. I'd just like to add that in situations where the settlement of the matrimonial flat and the issues of custody and care and control have already been addressed by an interim judgment, for instance, HDB is prepared to consider requests to submit flat applications depending on the facts of the particular case. So any parties undergoing a divorce may seek advice from HDB on their housing options. Thank you.
Mr. Alex Yam.
Thank you, Mr. Speaker. Without belabeling the point, I add my support to the Honourable Member Louis Ng's suggestion. Does the Ministry work together with the family courts in terms of coming to a mutual set of guidelines? Because in recent months there have been more cases of shared care and control that I've seen, and we've also had cases that we've come across with limited tenure shared care and control. So for example, a resident of mine was given shared care and control of the children with her spouse for only 10 months. And she was told by the courts that you need to resolve your housing situation within this 10 months. And this was quite distinct from all the other judgments in terms of divorce cases that I've seen over the last decade or so. So does the Ministry work closely with the family courts in terms of advising and coming up with these guidelines so that you don't have situations where the couples and the children end up suffering because of those judgments?
I thank the member for his supplementary question. I'd first like to add that in terms of numbers, as of 2016, shared care and control constitute 4% of all divorce care and control orders. So the numbers speak for themselves. As to your point about whether or not we work closely with family courts, I think we have to make decisions independently somewhat because we cannot be influencing the court decisions. But I take your point that we should closely monitor the number of cases of where parties are awarded shared care and control, and ensure that when they come to HDB, that we ensure that there are housing options for them on a needs basis. Thank you.
Mr. Louis Ng.
One last clarification or a suggestion. Can I suggest that at least we waive this ex-spousal consent for children to be listed as occupiers if the other party has moved on. Following the divorce, they now own private property or they own subsidized housing, which means they're remarried. Can the ex-spousal consent then be waived for the other party? Because I know of cases where both refuse to sign and both ends up renting homes because that's the whole reason why they divorced in the first place. They couldn't agree on things. So can we at least waive the ex-spousal consent for these cases?
I thank the member for his feedback. As I said, we'll look at each case on a case-by-case basis. So in the specific case that you mentioned, if the party that does not own the property after the divorce comes to HDB and satisfies the needs-based approach that we mentioned, then we'll work with him to ensure that he has housing options. Thank you.